This film presents findings from research conducted between April 2010 and June 2012 into the pre-proceedings process. This phase of practice directly precedes care proceedings and, in some instances, can lead to the case being diverted from court. Effective practice in this phase is an essential underpinning for meeting the proposed statutory time limit for care proceedings of 26 weeks. In this 12-minute film, researchers focus on the letter before proceedings and the pre-proceedings meeting in order to share messages from research with a practice audience.
I'm Judith Masson. I'm Professor of Socio-Legal Studies at Bristol University, and I've recently completed a study on the pre-proceedings process for care proceedings. The President of the Family Division has regarded the pre-proceedings process as vital in improving care proceedings and speeding them up. And I want to talk a little bit first about a study we conducted at Bristol and UEA on the pre-proceedings process. So what is the pre-proceedings process? It involves the local authority sending a letter to the parents explaining their concerns and calling the parents to a meeting to discuss these and plan for the child, and parents get a lawyer to attend the meeting with them. That's called a pre-proceedings meeting.
My name is Jonathan Dickens, and I'm a social work lecturer at the University of East Anglia, and I worked with Judith on the pre-proceedings study. So, what are the aims of the pre-proceedings process? There are two. The main one is to try to keep cases out of court, to give an opportunity, even for some very difficult cases, to be diverted from care proceedings. And in our study, a quarter of the cases were. We found that cases were kept out of court through improvements in parental care or agreement to alternative care arrangements. That might be with family and friends carers or might be Section 20 accommodation with foster carers. The other aim is to help speed up care proceedings. And this can be done by the discussions with the social workers and the lawyers, narrowing the issues in dispute, by giving time for assessments to be undertaken before care proceedings start, and by giving time for the paperwork and the documentation to be ordered and produced. Of course, there may be a tension between these two aims, because when a case starts off, you don't know for sure where it's going to end up. Some might make good progress, and it is possible to avoid going to court. In others, that might be something that has to happen. So the key is to keep actively monitoring the cases, reviewing them in social work supervision, and keeping a close eye with other colleagues and other agencies on how things are progressing.
So how does the pre-proceedings process work? First of all, we shouldn't just think about it as another meeting. These meetings are more serious. Parents regard them as a wake-up call. And it's also a different way of getting parents' attention. Seeing the concerns written down, parents found quite shocking. That was so even though many of them, the majority of them, had already had discussions about these concerns through the child protection process. So firstly, we have clear communication of concerns in the letter and in any discussions with the parents. Lawyers are seen very differently as social workers by parent clients. They see the lawyer as on their side. The message is then much less threatening and much more easily heard. So lawyers are providing partisan support, which parents find helpful, and they find having that support in the meeting makes it easier for them to communicate with social workers at the meeting. So the pre-proceedings process with the legal advice empowers the parents, and that encourages engagement with social workers, both directly through being told by their lawyer that they should engage, but also indirectly by feeling more in control and being able to play a part. That can lead to an agreement about how the parents should use children's services, how they should care for their child, possibly agreement for the child to stay with relatives for a time or longer term. And together, that can avoid the need for the case to go into proceedings. So how were local authorities using the pre-proceedings process? In our study, over 80% of the children were already on child protection plans, and so the pre-proceedings process was representing a step up, showing that the parents that it was more serious and really trying to get their attention because they hadn't been working sufficiently closely on the child protection plan. Of course, if it's a step up, it's also another step. It intervenes between what might be inexorably leading to care proceedings. And that reflects the idea that the pre-proceedings process can also cause delay or be something that the local authority does because it's reluctant to bring proceedings, not necessarily for good reasons. Second use of the pre-proceedings process was in planning for unborn babies. This was a very substantial use in our study. 30% of both our file study and our observed cases involved unborn babies. Ensuring that parents have a lawyer in any of the discussions can help the parents to understand, for example, what the consequences of refusing a pre-birth assessment might be, or what the consequences might be of not agreeing to some sort of protective measures when mum comes to leave hospital. It can also help to plan with parents about alternative care within the family, avoiding the need for either a mother and baby foster placement or for the child to be removed. It's also about fairness to parents. Because parents have independent advice, they can hear the messages about what might happen if they don't cooperate. And particularly it can avoid emergency action.
So the letter itself is fairly short and fairly clear. But what's attached to it is then a list of the concerns that the local authority has, and usually an example or two of what they mean and what help has been offered and why it hasn't worked. So key tips are: use subheadings, use bold, make it really clear. Don't put in lots of examples, short, to the point, use ordinary language. Make sure that what you say is accurate, because if you make a mistake and the parents challenge you about it, then you're on the back foot right away. Also, some of our local authorities did include a draft agreement with the letter. This wasn't always possible because it wasn't always ready. But if it is, that's, I think, a helpful thing to include. But what you must be careful to do, I think, is not to water down the seriousness of the message. In your natural instinct to present the message kindly, don't water down the seriousness of the situation. When you're talking to parents about the letter, do stress to them the importance of taking it and going to see a solicitor. It's especially important, of course, to think of that if you're working with a family with literacy difficulties or learning disabilities. But all parents need to know the importance of getting legal advice at this important time. If you can, think about the room that you're going to be using. Think about enough room, enough time. Don't just restrict the meeting to mother and father. Grandparents, aunts and uncles, friends too can sometimes play an important role in supporting the parents and in offering help in their childcare. Think about the time of day of the meeting. Think about offering childcare arrangements for the other children perhaps, or children coming out of school. Sometimes the parents might have taken the letter to the lawyer really quite late in the day, perhaps just the day before. So do be prepared to change the date. But as always, you have to be balancing that against the importance of not allowing things to drift on. Keep the focus on looking forward, on the positive agreement that you're going to help the parents to work with. If you have a draft agreement, it's often a good idea to give the parent and their lawyer some time before the meeting to discuss it privately between themselves. Also, allow them breaks in the middle to go out and discuss things. This can be really helpful for keeping parents calm and keeping parents engaged. Be clear and realistic about your expectations. You can expect perhaps some short-lived improvements. That's why it's important to set time limits and fix a review date. And what's really important, of course, is that you keep your side of the deal. And if you've offered services and support, you make sure that you provide that.
If we want to see if parents can change following the meeting, that has to be monitored. And we have to have clear timescales about when we're going to review these cases. And if parents haven't made sufficient progress, then we need to focus much more on preparing for court. So cases need ongoing review, and there may be short-lived changes, but we know, particularly in neglect cases, parents do improve from time to time, and it's quite easy to be taken in, to feel that there has been improvement when a colder, clearer look shows that the care is still very unsatisfactory. So we have to be careful not to allow these cases to drift in the pre-proceedings process. Making links with child protection reviews makes good use of existing reviews. We don't want to have to duplicate, but we do need to monitor what's happening. Social work supervision can assist with this. Have parents really changed, or are we just seeing a similar pattern as happened before using the process? And we found that drift was a particular concern in cases of long-term neglect. Some cases spent much too long in the pre-proceedings process, 12 to 18 months before the local authority brought proceedings. Looking back on those cases, there really hadn't been any progress under the pre-proceedings process.